Good afternoon. We will now reconvene the meeting. We have no, we'll rise from closed session without a report. And our first item of business is a delegation today, Mr. Rod Dew. If you'd like to attend to the mic, Rod, so you just push it on until it's red, and then when you're finished speaking, push it off and we'll get staff to respond or council to respond, okay?
I'm going to kind of build a story to explain to you why I'm so upset about the service level. In 2003, my father and I purchased a part of Concession 8, Part 5 from the township. At the time, it was deemed hazardous, so there was no taxes on it. Since that time, I've had nothing but problems with this municipality. In 2005, the township arbitrarily decided we're changing it from hazardous to farm residential, even though you can't build on it, so we can tax you. And I had no recourse but to pay the 3 years back taxes. In 2014, I applied for, with Impact, for relief on the tax level. And I won. I was advised by Impact that the settlement had been sent to this township in July. Come October, it still had not been placed in place. So I went to the mayor at that time and I told him if there was an issue, I need to know about it. If there wasn't an issue, I was going to retain a lawyer and I was going to legally come after the township. Not 30 minutes after I said that to the mayor, it showed up in somebody's office. Really? 2015, I attended the township office and I spoke with someone in the works department. At that time, there was a book that you would write things in. So 2-3 weeks later, nothing had happened. I hadn't heard anything. I come in, and when I entered the roads department, former mayor and former deputy mayor John Paulus was talking to Mr. Hancock. Well, first of all, Mr. Hancock said to me when I asked about that, there was no such thing as a book. Well, I saw a girl write it. So eventually I asked him about the service that I was requiring. He said they'd look at it. I never had any type of communication from the township, any form. No one came to my house. It wasn't a phone call, a letter, nothing. 2016, I was in Millbrook one day and I spotted Mr. Hancock parked in the Tupperville Plaza. I again, about the issue about the ditching. And while we were talking, the CAO came in and got in the truck with him. And we both went on, yep, we'll have it looked at. Well, guess what? I don't have to tell you. Nobody phoned, nobody sent a letter, nobody showed up to even look at it. 2016, at the regular meeting, council signed to establish a road allowance on Cedar Crescent. When I bought the property, it was a forced road. And most of you here probably don't know, but at one time that road, which is down Cedar Crescent, was Hutchison Drive. There was a bridge there. I think Mr. Edgerton and I are probably the only ones who would remember it. And what was interesting, I was told at that time, oh no, it's not a forced road. Well, the Manley Farm was sold at that time and the township gave it back. And I have the letter right here from their lawyer. And it states it was a forced road. Well, according to the Ontario government, forced roads do not have road allowance. So, and I found this out 2 years after it happened. Never even the courtesy to send a letter to the residents to tell them this was happening. 2017, I sent a letter to this township. Mayor McFadden showed up at my house, and it was about the way people were being treated and how things were going and issues. We're going to deal with it. Don't worry. Well, they had the meeting and it was, I think somebody sneezed and it was over with. Not one person asked any questions. There were no comments, no nothing. If I was the conspiracy type person, I'd have swore it was all talked about prior to the meeting. And again, nothing ever happened. 2019, the township updated its parking bylaws. Part of it was that the east side of Cedar Crescent would be a no parking area because I had a problem with people who would be coming in and fishing. And what they would do is they'd clean their fish on my lawn, leave their garbage and their worms and everything else there. Well, I'm not cleaning up other people's garbage. So anyway, this was 2019, it was passed. But to enforce a bylaw, I was told you have to have the signs up. This is now to 2023. No signs on the road yet. They must be in the back of the building. 2021, I requested the same work again. And a township employee did come over to my house and he spoke to me, looked at it all. He said, yes, you're absolutely right, Mr. Dew, this needs to be done. Next thing I know, he's working in another township. Nothing. Never received any communication, never received anything, verbal, written, nothing. When the budget last year was being made, or I sent an email, Mr. Hancock, and I have a copy of the email with me. In fact, I've got a lot of evidence with me. And I asked that it be looked at for this year. Never even got an email to say, thank you, yes, it'll be considered, nothing. So that brings me to 2023. Well, during the winter, they took the grader out and they pushed the snow back. Well, what they did in the ditch across the road from that I own, the lot, cut the top off the ditch and threw it all in the ditch. So when I went to clean it out this year, all I had was a pile of sand, garbage, everything. So after 20 years of hard work, and I mean, it was hard work to get that place looking nice, the ditch was just destroyed. So here I stand. I'm a 64 disabled senior. And I want an answer, and I want it from the mayor. I know I'm not a big developer. I'm not Tower Hill. I'm not Kawartha Downs. I don't run a golf course for a big business in this township. I'm what you would call the lowest of the low. I'm a taxpayer who has been disrespected by this municipality. And if I can tell you this for a fact, if this had happened on my job when I worked for the Ontario government, I'd have been in the unemployment line because that's not tolerated. The public is number one. So the work still needs done. I want the township to hire an outside engineer and an outside company to do the work because I have little or no faith in this township right now. None whatsoever. You know, there's no saying respect is earned. Well, if there was a scale for it, it hasn't even moved off the bottom line as far as I'm concerned. So I will say that there were two chaps come over to my place last week and they talked about it. So I said, will there be a report written about this so that, you know, it's on? Oh, no, they won't need to write a report. I ain't falling for that one again. I don't trust anybody. That's why I want an outside contractor. So I have a question for you, Mr. Mayor. Can you justify the treatment I have received from this township? And I don't want to hear from anybody else but the mayor. No, I've got other questions. Yep, Manfred. Oh, I got.
Yeah, through you, Rod. So obviously, it's a long story, and I'm first of all, I don't think it's an acceptable treatment that you've received for sure. And I think most of my members of council and present today would agree with me that that's a very frustrating circumstance. It's completely understood. With regards to my involvement of it, have you sent correspondence to me about this issue? Sorry, Rob. Yeah.
You've only been mayor for a few weeks. So, but I have got documentation here that from when Fadden was mayor to the different things that were done from impact, everything. And I'm just not going to take it anymore.
No problem. Like I said, you asked me for my answer, and since this delegation, this is the first, and just to be clear as well, I think the initial conversation or the main vein of the concerns, because there's allusions to a few other things, is ditch work, is ditching with regards to the properties, correct? Perfect. Okay. So this is the first with this delegation request, and there wasn't a ton of information in there, but this is the first address or time it's been brought up to my attention. So I don't really have much to contribute other than my apologies for the feeling and the treatment that you've received and the lack of response. As I've spoken with the CAO, and there is a constant focus since, well, during deputy mayor, when I was the deputy mayor as well, about trying to improve KPIs and making sure that when we receive correspondence from staff or the staff receive correspondence from the public, that there's a commitment and a timeline by which they can receive a response. So that is how that's a constant focus. That's been a priority. I've made that clear since the start. It's a work in progress, so it's not perfect yet, but we're working on improving within our procedural bylaws and the other documents that govern how the staff run their different departments. We're working on granular deliverables in that. And so that's the CAO's project, and she's working on that. With regards to my involvement, I'd like to ask Mr. Hancock for his explanation to some of this, but if you don't want to hear it, then I don't need to ask him because you asked for my response. So like I said, in the future, I'm not sure if did you send any correspondence on this issue or the history on this issue? Because when there's transitions between governors, I don't get access to all of the mayor's documents. And if Mayor McFadden leaves things didn't leave me a report to say, these are some outstanding things you might want to look out for, but we worked pretty closely during the last 4 years. So there's some overlap in those discussions, but it's not like there's a laundry list or I get the key to the files and see all the history of the correspondence. I don't get that. You're starting fresh with the office. So I can't speak to some of that backlog, but I do advocate and I do recommend that when issues occur and you're not satisfied, or if you're just bringing the issue to the attention of staff, to include your ward representative, myself and the deputy mayor at all times, because unless it's in a report from staff or unless it's brought to us directly, we're not involved on the sort of day-to-day operations outside of those reports. So that wasn't done yet, but like I said, it's only been a few months. So, but that being said, if you don't want to hear from Mr. Hancock, I'm not going to call on him for a comment, but we can receive your delegation at this time. But as far as some of the work that you're talking about, I believe there are plans to get to that ditching work this year if it hasn't been done already. I'm not sure. I don't set those timelines and those parameters. Planning and public works staff do that without our direction once we approve the budget. So that's sort of the extent of my comments, but if you have more questions, I'm happy to answer them. Okay. So I got to turn mine off and then you can.
My question is it the policy of the township to handle people this way? And if it's not, then why has it been allowed to go on for so long? I'm not the only one. I hear it from all kinds of people how they're disrespected by people here. And it's got to stop. We're the ones paying the damn bills here. Now, as you heard, I said I want an outside engineer and an outside company. If you're not going to do that, I want you to leave it as it is. I'll wait till the next mayor gets elected. And I hear that he's retiring. So hopefully he'll be gone in the next 4 years. Because I'm telling you, I have no faith in this township whatsoever. None. And if I have to, I'll get a restraining order to stop them. To do the work. I don't want them doing the work. I want somebody I can trust. Okay, that's all I've got to say. I didn't want to come here today, but I was forced.
Thank you, Mr. Dew. Any questions, members of council? Councilor Byrne.
Through you, Chair, not really a question, just a comment. I was down, I looked at the site in the last month. I know some of the culverts looked about 12 inches. I could barely get my safety boot into what's left of the opening. So I say it needs done. I have reservations because it is township property and I'm trying my damnedest to find ways that we don't have to raise taxes. So on the subject of an outside firm doing it, I get your reluctance, I get your fear, I get all the concerns. I just don't like to see taxpayers' money wasted either. So some balance in there would be great. I don't know what you can do on that notion, but that'd be my only comment. Thanks for coming.
Thanks, Chair. Any other questions, members of council? Councilor Edgerton?
Thanks for bringing it to our concern, Mr. Dew, but I think on due respect that now it has been brought up here at council at this meeting, that maybe our work department can get down and get the job done that you would like to see done without hiring outside people to spend our tax dollars. Because I also pay taxes like you do. And I think we should give them one chance now that you brought it up to get down and get it done right. Thank you.
Councilor Natchoff, and then I'll come back to it.
I also relate our condolences or apologies on how you felt you've been treated over the previous 15 years that you've documented. To echo the sentiments of Councilor Edgerton, I think if you were to allow the current council the opportunity to try to do best by you, I think in good faith that would be on your behalf something that at least allows us the opportunity to make do. If of course you don't want to do that, you're more than welcome to go with what recourse you choose to do that. But once again, I appreciate your frustrations, and as your counselor, moving forward, I'm always here to hear the complaints of my constituents. This is the first that I've been made aware of this as your counselor. If such circumstances arise, whether this issue or other ones, please feel free to contact me to be your liaison so that we can better have communications with the rest of the township.
One thing I'll say before I leave. I will allow or accept the township doing the work. But I want a written report as to what's being done, what's going, like, how it's going to be done. And I want the public works manager to sign it. I want the CAO to sign it, and I want the mayor to sign it. So if nothing happens, I can bring that back to the public and say, there.
Thanks, Rod. Ms. Hurley, I might ask you, is it a possibility that we could get such a document and provide it to Mr. Dew with a summary of the works that are to be done in the property?
Through you, Mr. Chairman, to Mr. Dew, we can certainly follow up with a document that shows and identifies the exact works that we're going to, that are going to be carried out. With regards to signing, I'm not sure if that's going to help the situation, but I can certainly sign it, and I can certainly have the Public Works Director sign it. But as for the mayor, I'd probably not have the mayor sign, as the mayor changes every 4 years. But at this, or maybe not, I'm not sure. But we can certainly sign as staff and ensure the works identified prior to getting the works done, and certainly meet with you after to ensure the works are done to your satisfaction as well as our satisfaction.
Is that acceptable? Very good. Thank you very much for the delegation, Rod. Apologies for the experience you've occurred, and we'll hopefully to work better forward in the future. Very good. So we received that delegation for information. Need a mover, Councilor Byrne, Councilor Natchoff, all in favor? That is carried. Very good. Well, now we have a few public meetings that we're going into today. So 8.1 is the first. We'll need a resolution to open this public meeting. Councilor Byrne, Councilor Natchoff, all in favor? That's approved. Very well. We'll now receive the report for the public meeting, and I believe Ms. Ellis will be providing that report. Ms. Ellis.
Thank you, Mayor Graham, members of council, members of staff, and the public. The public meeting today is about a proposed official plan and zoning bylaw amendment for lands located at 1657 Mount Pleasant Road in part of Lot 22, Concession 13. The official plan and zoning bylaw amendments are required to permit the establishment of 2 on-farm diversified uses on a portion of the property. The proposed uses will include a light metal working shop and an electrician's shop. The proposed uses are to be established in an existing building on the property with a gross floor area of approximately 429 square meters or 4,600 square feet. The uses are anticipated to operate on a regular 9 a.m. to 5 p.m. Monday to Friday schedule. Additional uses may occur for special events on an infrequent basis, such as emergency repairs. Together with the building space, a dedicated parking space is proposed. The existing gravel driveway will be used to access the parking area and the building. The total lot area dedicated to proposed on-farm diversified uses, which includes the building and parking area, is approximately 0.17 hectares or 0.43 acres. Currently in the township's official plan, we do not permit the establishment of on-farm diversified uses. That's why an official plan amendment is required. And for members of the public, this official plan amendment will apply to the agricultural portion of the property only. So we will be changing, or is proposed to change, the designation on the property to an exception designation. So what that means is that the agricultural designation will remain, but an exception policy will be added that will state that in addition to the uses permitted in section 5.1.2 of the plan, which are the standard agricultural designation policies, small scale on-farm diversified uses may be permitted subject to a number of criteria. The criteria include the fact that the on-farm diversified uses remain secondary to the principal agricultural use of the property and be limited in area of up to 2% of the farm parcel to a maximum of 1 hectare. Secondly, will require that the buildings and structures housing the on-farm diversified uses are located within the existing farm building cluster. Thirdly, the on-farm diversified uses must be compatible with surrounding land uses in accordance with the policies of the official plan and shall not conflict or interfere with the principal agricultural uses on the property or normal farm practices in the area. Fourthly, the on-farm diversified uses cannot permanently displace agricultural land. Fifthly, it requires minimal site grading and or drainage unless it improves conditions for agricultural production. It may be required to demonstrate that there is a sufficient quality and quantity of water supply to service the proposed use. Impacts must be mitigated to the site itself and the surrounding agricultural operations, including but not limited to compaction, drainage, and trespassing. The uses must meet the requirements of section 3.27, minimum distance separation, 7.3, which is the road network, and 8.7, site plan control. The uses must meet any other requirement deemed necessary by the Township of Cavan-Monaghan, Peterborough County, and or a commenting agency. And for the public's information, a commenting agency would be an agency like Peterborough Public Health. Where there is more than one on-farm diversified use, the combined area of all uses cannot exceed the lot area criteria outlined above. And lastly, the applicant must demonstrate that they are a bona fide farmer by providing their farm business registration number. So those are the exception policies proposed to date to change the official plan. So the key thing to remember, agricultural uses still remain the primary use of the property. But in this particular case, in an existing farm building on the property, permission could be granted for up to 2 on-farm diversified uses with a floor area in an existing building of about 4,600 square feet. On-site parking will also be provided to service that. In the township zoning bylaw, we do permit on-farm diversified uses, but with this application, some exceptions to the standard on-farm diversified use regulations are required. So with the zoning bylaw amendment, and again, the zoning bylaw amendment applies to the agricultural portion of the property only. So in this particular case, we are proposing to change the minimum lot area requirement to 18 hectares. So that is the area in the agricultural designation, or the zone, sorry. The property is larger than that, but the zone of agriculture will be 18 hectares. Secondly, Notwithstanding the regulations in the zoning bylaw, the total gross floor area that is permanently, temporarily, or seasonally devoted to on-farm diversified uses, farm businesses, or agritourism uses shall not exceed 550 square meters, including the gross floor areas used within all principal buildings or structures and accessory buildings or structures on the lot. And lastly, notwithstanding the standard provisions in the zoning bylaw, an on-farm diversified use may be operated by a person whose principal residence is not the dwelling on the lot, and a maximum of 4 persons other than residents of the dwelling on the lot are permitted to be employed in the businesses of the uses. So normally in the township zoning bylaw today, to have an on-farm diversified use, it's operated by people who live in the house and a limited number of employees, which are 2. In this particular case, we're exempting or permitting a greater number of employees who don't live on site to be employed in the uses. So that's an exception that is a little bit different from the standard. With these applications, just so members of council and the public know, another application will be required if the official plan and zoning bylaw amendment get approved. The uses will be regulated further through site plan control. Site plan control is another Planning Act application, which will identify where the building sits on the property, where the parking is to go, where any waste is stored, and how it's picked up, the servicing on the site, drainage, etc. All of those operational issues will be regulated through site plan control. In accordance with the requirements of the Planning Act, this notice of these applications was circulated by first-class prepaid mail to all assessed persons within 120 meters or 400 feet of the land subject to the applications. A sign was posted on the property. We also circulated required ministries and agencies, and management staff in the township were circulated. The notice provided satisfies the requirements of the Planning Act. As indicated in the report, township staff, we did receive 2 telephone inquiries from members of the public asking questions, but they did not express any objections to the applications in those telephone conversations. Staff have no objections to the applications. The building and fire departments have noted that a building permit is required for the change of use and renovation of the existing building. On-site water for firefighting may be required, depending on the Ontario Building Code classification of the building. Peterborough Public Health has confirmed there is no record of a permit for a private septic system for the agricultural building. But that servicing will be reviewed at the time of site plan approval. And Peterborough Public Health has further confirmed in writing that they have no objection to the amendments. But the owner needs to apply and be approved for an existing sewage system permit prior to the issuance of the building permit. Kawartha Pine Ridge District School Board reviewed the applications and did not identify any concerns with it relative to their mandate. Peterborough County Public Works has been circulated the traffic impact study that was provided in support of the application. The peer review of that traffic impact study has not occurred yet, so we do not have their comments. We will be expecting their comments as soon as possible. Autonomy Conservation has provided comments, and they have indicated that these applications do conform to section 3.1 of the provincial policy statement. The lands are not located within a vulnerable area with regard to source water protection, and a permit is not required for the proposed uses. And they've also indicated, as an adjacent land owner, that the applications will not have any impacts on their lands. The planning report before you provides an analysis of the applications with regard to the township's official plan, Peterborough County official plan, the provincial policy statement, and the growth plan for the Greater Golden Horseshoe. You will notice in the report that there is an outstanding issue relative to the minimum distance separation. It is a requirement that on-farm diversified uses meet the minimum distance separation requirements. There is a regulation in the zoning bylaw, however, that says if it's low human occupancy and low traffic generation, MDS does not necessarily need to be calculated. So in this particular case, with the information we have today, we couldn't confirm that MDS is not to be applied to these applications. So the applications do not conform to the townships and county official plan at this moment in time. I have spoken with the planning consultant for the application, and we just need some additional information confirming what we believe to be true, that these are low impact in terms of human occupancy and traffic. So we believe that MDS can be satisfied and does not need to be calculated, but we just need that information from the planning consultant. And I believe that we will be getting that post haste. So having said all of that, I am here to answer any questions. And just so you know, the recommendations for members of the public, the recommendations in the report today are that council review and consider all public and agency verbal and written comments received, and that the draft official plan and zoning bylaw amendment be presented to council at a future date for consideration.
Thank you, Ms. Ellis. Questions, members of council? Councilor Byrne.
Through the chair, two things. Under the amendments thing, item 9, being new here, what do any other requirements? What kind of umbrella does that open?
Through you, Mayor Graham, to members of council, members of the public, those other requirements generally will deal with things like drainage. It's just put in there so we can use that policy to help us direct the site plan that will come as part of the applications.
Through you, chair, on that note, at this point in time, is staff aware if there is a working septic system in that location and if the well is up to snuff?
Through you, Mayor Graham, to members of council, members of the public. So staff have received confirmation from the applicant's agent that the building for the on-farm diversified uses is serviced by the well that services all of the buildings on the property. There is apparently a holding tank that is in place to service the building that will be used for the on-farm diversified uses. As I've indicated in the report, I'm not aware that there is a permit for that holding tank, but that is something that we will follow up with Peterborough Public Health. And that is something that will be required to be in place when we get to the site plan approval stage.
I had a question with regards to MDS, but you've answered it quite well at the end there with regards to, so my concern is I was under the impression that MDS can be a real like deal breaker at times, but it sounds as though from your description, I just wanted to confirm while we have you before we open it to the public, that it sounds as though, I mean, I think of most agricultural places, there's light metal works and a lot of electrical work going on, sometimes in the same facilities where some of these livestock or farm related purposes might be. So I don't have a ton of concerns with the proximity from, I believe it's horses that are on this farm or this property specifically. But so what you're insinuating, if I'm reading it or hearing you correctly, is that there are different thresholds for enforcement when it comes to MDS. So it's not like you either are satisfied or you aren't, but depending on what is being considered in the auxiliary building, that, you know, obviously the existing building isn't going to up and move a few feet over to get a few further away so that it's fully resolved from the radius that MDS is calculated on. But it sounds as though that there's at least hope to believe it won't be such a deal breaker from preventing, you know, what I think is a viable opportunity to move forward.
Through you, Mayor Graham, to members of council, members of the public, you are correct. So MDS is, as you know, being in a rural area, we calculate MDS for just about everything. But there is a regulation in the township zoning bylaw that says, yes, we calculate MDS, and there's policies in the official plan saying these have to conform to the MDS. But there is a provision in the bylaw that says if you have low human occupancy and low traffic, then MDS does not necessarily need to be calculated. So, and I believe that the uses proposed with these on-farm diversified uses meet that criteria. So I think we're okay. In addition, I think there is, it's my understanding, and the planning consultant can correct me if I'm wrong, but there's a horse on the property, but there's just a shelter that we wouldn't calculate MDS for. And we know that there's livestock facilities at a property across the road a little bit to the east, but we haven't calculated, but you know, push comes to shove, we can calculate and we can all go from there. But I do believe we can meet the MDS.
Well, should do a history lesson and go back to whoever drafted that part of the bylaw and give them kudos, because it's good to have proportionality to it. And it's nice to hear that that's reflected, because I know we're often updating bylaws to have more accountability or more maneuverability for those sorts of things. So that's great. Other questions before we open it up for the public? Seeing none. Very good. We'll open the floor. So same process with the mic. If you want to speak, you just approach the mic, hit the red, and then when you're finished speaking, and you want an answer, you can just tap the mic on again, but we're opening now for members of the public. If you can just state your name and your address when you're coming to speak, that would be very helpful for staff to take note of that. Thank you very much.
Good afternoon through the chair. Good afternoon, Mr. Mayor, members of council and members of public in attendance. My name is Marnie Saunders. I'm a land use planner with DM Wills, and I'm here to speak on behalf of the owner of the property subject to OPA 01-23 and ZBA 01-23. So as outlined in staff's report, the proposed amendment is to permit 2 on-farm diversified uses on the property within an existing agriculture-related building or underutilized agriculture-related building on the subject property. The proposed use will use less than 0.25 hectares of the property, which is also equates to less than half an acre of the subject property. The building is currently serviced by existing well, which services all the buildings on the subject property. And as Karen mentioned, it is serviced by a holding tank. The owner acknowledges and understands that through the site plan process and prior to any issuance of building permits, that there may need to be existing septic permits issued for that system, which may also involve that the system may need to be inspected and or upgraded. As well as the MDS comments that were made, I can confirm that as per staff's comments this afternoon, it will not be a high human traffic use, so there will not be significant human visitation or traffic generated from the use. There'll be less than 4 employees. The light metal workshop won't actually have any customers other than dropping off or picking up vehicles. And the electrician shop is more so just a shop for the electrician to kind of touch base in the morning and at the end of the day and store some of their equipment and material and supplies. Otherwise, with regard to the minimum distance setback, there is 1 horse on the property and some free run chicken. There's no livestock facility. There is a covered shelter for the horse and a small coop for the handful of chicken that are on the property. But there's no livestock facility. There is a vacant livestock barns across the road to the northeast. It's been confirmed that they are vacant. However, based on the provincial guidelines for minimum distance setback, there is a guideline. It's guideline number 35 in that publication that speaks specifically to on-farm diversified and agricultural related uses being exempt or not requiring the minimum distance setback calculation unless there is going to be the higher volumes of traffic on the property and higher levels of human occupancy. So typically that's for uses like agritourism uses, wineries, uses to that effect, or those similar on-farm diversified uses that create that higher generation of traffic. Otherwise, we agree with staff's report and we feel that the proposed uses are consistent with provincial policy, the county's official plan, and the township's official plan and zoning bylaw, and represents good planning. That concludes my presentation. If there's any other questions or comments from council or the public at this time, I'd be happy to answer those.
Thank you, Ms. Saunders. I don't know if there's any comments while Saunders is at the podium. Otherwise, we'll just open it up for the next participant. Thank you, Ms. Saunders. Other members of the public wishing to speak, just come forward as you will. Going once, going twice. Okay. At this point now, we're at the considerations of the report. Council, so before us today, we're just reviewing, consider all written and verbal comments in the public meeting, and that the draft official plan amendment and zoning bylaw amendments will be presented to council at a future date. Moved by Councillor Byrne, seconded by Councillor Natchoff. All in favor? That is approved. We now need a motion to close this public meeting. Councillor Byrne, Councillor Natchoff, all in favor? That is approved. Don't go anywhere. We're going to need a motion to open the next public meeting. Councillor Edgerton and Councillor Natchoff. All in favor? That is also approved. We will now receive the presentation from Rochelle Rock, if you'd like to move forward to the podium, will she be virtually? Ah, very good. Of course, virtually.
Yes.
Or I'll leave it with you, Carly, and you can bring her in.
I am here. So
Welcome, Michelle.
thank you very much for your time and thank you for letting me attend virtually today. I greatly appreciate it. Just to provide a bit of outline, Township planning staff had hired Biglieri Group to assist in implementing changes that have been implemented by the province, particularly with respect to Bill 109 and Bill 23, and then assist with putting together the amendments that would be required to the official plan, the zoning bylaw, as well as how it trickles down to your site plan control bylaws, your pre-consultation bylaw, delegation bylaw, and then ultimately your user fee bylaw. So if we could go to the next slide. So Bill 109 was also named the More Homes for Everyone Act, received royal assent on April 14th, 2022. So it made a number of changes to the Planning Act, some of which were supposed to come into force and effect on January 1st of 2023, but due to requests by multiple municipalities, that date was deferred, particularly for the application fee refunds. That was deferred until July 1st, 2023, which is why we're here now. So one of the changes that was made was to the delegation for site plan control. So under section 41 of the Planning Act, which is the site plan control section, a new clause was included that said that for every municipality who has designated site plan control area, those municipalities must have designated the approval of a site plan control to an agent of the municipality or to an employee. And then in addition to the changes under the site plan section, it now requires that developments that have 10 residential units or less are now exempt from site plan control approval. That means anybody who is proposing 11 units or more, still subject to the old rules. Anything with 10 units or less, it would strictly be your building permit process. And then the biggest change that was made out of Bill 109 was the application fee refunds. So what happens, and there has always been within the Planning Act, requirements for municipalities to process applications within a certain period of time. And if those applications weren't reviewed, either approved or denied within that time frame, the applicant could appeal to the Ontario Land Tribunal, previously the local planning tribunal, or to Ontario Municipal Board. Same body, different name. What Bill 109 introduced was a series of refunds that would be required. So for site plans, if a municipality approves their site plans within 60 days, no refund is given. If the plans, and that 60 days, your time limit for site plans, anything approved after that, or within additional 25 days, they have to give back 50% of the application fee. And then it goes to a 75% reduction. And then if your application is approved within 120 days or after 120 days, the municipality is required to give back all of the application fees. Those same changes were made for zoning amendments as well for official plan amendments. So in addition to having to review all of these applications, now municipalities are also faced with giving application refunds if approvals are not given within that time frame. So changes needed to be made to the fees and service bylaw, which I'll get into in a minute. So if I could have the next slide. So after Bill 109 came into force and effect and received royal assent on November 28th, Bill 23, also known as More Homes Built Faster, was also created and approved by the province. This went one step further and made an additional number of changes to the Planning Act, as well as a whole host of other acts that impact development at the provincial level. So the first one that was one of the first main items that was created, and we have it down twice because it's so important, was additional residential units, or ADUs or ARUs. Each municipality terms it differently. Now allows for a maximum of 2 additional units for all residential lands that allow for single detached, semi-detached, or a row house within your urban serviced area. So that means that every single semi or town is now allowed to have either 3 units within the main dwelling, or 2 units within the main dwelling and 1 accessory structure. The idea is to allow for these additional units to be created. In addition to that, it also states that you're not allowed to require more than 1 parking space per unit in these for these units. The changes to the parkland, all of which haven't come into force and effect because there are still a number of regulations that haven't been developed by the province, and there are still a number of items that, because those regulations haven't been written and aren't fully understood, those sections of changes to the Planning Act aren't in force. But one of the major ones was with respect to the alternative parkland dedication requirement. So typically it is 5% of the value of the land or the area of the land as part of an application has to be provided to a municipality for parkland purposes. Where there are larger developments that are occupying a larger area of land, or producing a higher number of units, often an alternative rate was required. So the previous alternative rate was 1 hectare per 300 units. For Bill 23, that ratio has been increased to 1 hectare per 600 units. There are also a number of changes that will need to be made, which will tie into your Parks and Recreation Master Plan, and that municipalities have to have a Parks and Recreation Master Plan so that they can identify what their parkland needs are. Parkland funds go into a specific fund within the municipality that can only be used for parkland purposes. Through Bill 23, there's now going to be a requirement that municipalities have to use those funds within a specified amount of time for those uses which have been identified through your parks plan. Then in addition, there were changes made to the Ontario Heritage Act. Those changes at a high level speak to the municipal record, that sort of the heritage register that municipalities create, that don't designate properties, but identify properties that might have historic characteristics. And at some point, the municipality may want to register under the Ontario Heritage Act. That's been slightly changed, that now you must have reasons for putting properties on that register. In addition to that, if you put a property on the heritage register, you either have to register it as being a historic building within 2 years, or it has to come off the register. What was happening is that properties would be put on the heritage register and then would just stay there. There are also new restrictions with respect to municipalities having a limit in the amount of time they can determine to register a property if an application under the Planning Act is coming in that would allow for the demolition. So changes have been made to how things get registered. So next slide, please. So as part of this, as identified, there are a number of amendments that need to be made to the township's official plan. So next slide, please. So the proposed changes are to delegate the power of site plan control to staff. This is something that the Planning Act says you have to do. Allow the executive director of planning and development or the chief administrative officer to remove the holding provision. The power to do this has always been permitted under the Planning Act. But if you're looking and if you're required to delegate the site plan control to staff, it makes sense to also allow staff to remove the holding provision. It still requires the applicant to come forward with a zoning amendment, and council still has to approve that. But what typically would happen in the past is that the zoning bylaw amendment would get put in place. A holding provision would put on so that if there were any studies or any additional requirements that needed to be completed, that the applicant would complete them, but then it would have to come back to council to have that lifted, even though the approval of whatever that condition and the review of that condition is typically done by staff. So allowing a designate of council to remove that holding will also help speed up the process and allow people to move forward towards building and developing quicker. Increase in the number of accessory apartments allowed in the serviced urban area. This is also consistent with the changes under the Planning Act, including the prorated refund for development applications, if not marked complete and not approved, also consistent with the changes in the Planning Act, and then making the changes to the parkland provision regarding that changed alternative rate from 1 hectare per 300 units to 1 hectare per 600 units. Next slide, please. So the zoning amendments that will now be required. Next slide. So proposed changes to the zoning are to increase the number of accessory dwelling units in the serviced area to identify that it's 2 accessory dwelling units per residential property with any lot that permits a single detached dwelling, a semi-detached dwelling, or a row house dwelling. And then to amend the definition so that it allows these accessory units to be put into accessory dwelling or accessory buildings as well as in the main building. And next slide, please. Next slide. So as previously identified, to delegate the site plan control approval from council to staff. And this is just consistent with the requirements. Next slide. And so the township has a pre-consultation bylaw. Changes needed to be made to that, partly in response to the requirement of having to refund application fees if complete applications aren't processed within that specified time period. So what, in working with staff, we've proposed is to split the pre-consultation process by major applications and minor applications, and to introduce the pre-application process. So we've identified that through discussions with township staff is to identify those applications that have been determined as minor that can go straight to a full application. So those would be minor variances, rezoning applications that have been provided as a condition of an approved subdivision, or are required as part of a severance application where it's a surplus farm severance and they need to put an agricultural purposes only zoning on the property, as well as any other consent applications that have required a zoning amendment. The idea is that these are fairly straightforward applications and can be processed within the time period set out under the Act, and the township won't be providing refunds. For major applications, those being your official plan amendments, your zoning bylaw amendments, and your plans of subdivision, which typically take more time, are dependent on agencies providing their comments and responses to township staff. And the timeframes are a little bit more, they're not as easy to achieve. And there's a greater risk that the township will have to provide refunds for those applications to introduce the pre-application. And that would be going through a pre-consultation process, submitting a complete application, and then a full review would be done at that stage. Once staff are satisfied the application is something that has provided all of the required studies, all of the comments and all of the concerns have been addressed from township staff, outside agencies, then the applicant could move forward with a full application under the Planning Act. This pre-application process is consistent with what the majority of municipalities across Ontario have implemented. In an effort to defer any risks of having to refund application fees. So next slide, please. And so changes also need to be made to the delegation bylaw with respect to both the site plan approval as well as lifting of the holding bylaw. So next slide, please. And then the user fees bylaw needs to be updated to now charge a fee for the pre-consultation meeting, as well as provide a fee for the pre-application process, and then to include the requirement of the refund for any development applications which can't be or haven't been processed within the allotted time under the Planning Act. So last slide, if there are any questions, I am more than happy to answer.
Thank you for that, Rochelle. John, Mr. Conley does have a report on this. If there are questions for Rochelle, are you able to stay with us after John's presentation and his report, or would you like your questions now?
I have blocked the entire afternoon off for you, so I am very much available.
Very good. Thank you, Rochelle. So if council's okay, we'll just proceed with John's report and then go back to questions either way. Okay, very good. Mr. Conley.
Thank you, Worship, through you to council, to those members of the public who are here, present or watching. What we have before you is Planning Report 2023-23, Bill 109 and Bill 23 official plans, zoning bylaw amendments. This is the public meeting report for files number OP 0223 and ZBA 023, with two recommendations: that council review and consider all verbal and written comments received at the public meeting, and secondly, that the draft official plan amendment, zoning bylaw, and other bylaw amendments presented to council at a future date for consideration. As Rochelle from Big Larry had identified, the package includes the official plan amendment and the zoning bylaw amendments, as well as 4 other bylaws that need to be changed, which sort of cascade down from decisions made through Bill 109, Bill 23, and implementation at the local level. Without redoing some of the information that was presented by Rochelle, Specifically, what we see is we looked at other jurisdictions, looked at what was being done. We looked at trying to suit and tailor this to how we could be responsive and also encompass where Bill 109 and Bill 23 are trying to get decisions. We also look at from a track record of how quickly we're able to look at these applications and introduce that through a pre-application process and the idea of getting some of that work done ahead of time. And with that, we've designed this suite of changes, not only responding to just Bill 109 and Bill 23, but overall, we feel is a good way of streamlining and making the development decision-making process that much more efficient. Notice of the official plan and zoning bylaw amendments, as well as the selected bylaws, were circulated to all required ministries and agencies, township department directors. The notice of the public meeting was also posted on the township website, published in the Peterborough Examiner, as well as the Millbrook Times. The notice complies with the Planning Act. As of the date of writing this report, township staff have not received any telephone inquiries or email inquiries about the applications. The Kawartha Pine Ridge District School Board reviewed the applications, did not identify any concerns related to their mandate. Enbridge Gas indicated that no objections, but reserves the right to amend their development consideration conditions. And Bell as well. Bell Canada said that they have no concerns that came in after the report was written. So what you have before you is when this is approved, if it is approved, Township Council, the official plan and the zoning bylaw amendments, as well as the other, will go for approval here. And then because it's an official plan amendment, that's to the county. So what will happen is we'll bring this report back to council for a final decision, its decision, looking for June 5th to do that. And then after that, we would send that on to the county as they are the final decision maker with respect to the official plan. If you have any questions whatsoever, either myself or Rochelle are here to answer.
Thank you, Mr. Conley. So that report's before us, but as Rochelle mentioned, we do have her on for any questions from members of council with regards to either the presentation or the report before us. Councilor Byrne.
Through the chair to the presentation, you mentioned in the Bill 23 highlights about the additional units. I was kind of under the impression you mentioned it's for all urban, but does it have to have wastewater to qualify for that?
Through the chair, the way that it is written in the act is that it has to have municipal services. So anything that is on municipal services automatically has the ability to have these 3 units.
Yes, that's good. Now, when you're talking about the deadlines for the 60 days or whatever and the penalties that might be involved, are they business days or are they calendar days? And does any consideration put into summer vacations for all these other agencies and problems that get impacted by that?
Through the chair, it's calendar days and there's no exceptions given.
Is there any logic to that?
Through the chair, I can't speak to what the provincial logic to that was. These dates have historically been within the Planning Act for as long as I can remember. So these dates have always been, it's always been 60 days for, actually, no, it's been 30 days for site plans. It has switched back and forth from 90 days for zoning amendments to 120 days, to 120 to 180 days for official plan amendments. So the dates are always there. What's new is having to refund fees. I think the idea behind requiring municipalities to refund the fees is that it will provide the impetus to move these applications forward. I'm not sure that it always works, particularly because, and in my former municipal life, I will tell you that some of the worst offenders on getting comments back are provincial agencies themselves. However, the idea is in order to get more shovels in the ground, get more homes built, that requiring municipalities to refund these application fees is one of the tools that the province is using to speed things up.
I believe Mr. Conley would like to speak to it as well.
Through your chair to council and everyone in attendance, the public and listening. So traditionally, as Rochelle had indicated, that has been in the Planning Act, and I think the idea is applying some sense of reasonable. The idea that anything could be in 60, 90 days, so 2 or 3 months or half a year has always sort of been the guiding principle. With this one, with the relief and the changes to that, the notion of a house for everyone and building homes faster is with the introduction of these efficiencies with these amendments, these changes, is the idea that we want to get housing supply out there and do it faster with the notion that there'll be a penalty. And we've tried to, in working with the consultant and looking at our experience locally, tried to present a balance to council as to where we know there are places, loggerheads or delays in the process, try to get that to a point where we can refine applications so that the application, once it is complete, used to be that we would just, well, it is right now, that if we had everything and it said there was a report, we would say it's complete. If the contents of the report were not thorough enough or did enough due diligence, we would go back and forth and getting more information and quite honestly lose weeks and days on that. In this case, what we would do is that the notion of a complete application would be something that's this is something that's there and ready for approval. Hope being that when we make a decision or present it to council for a decision, that time frame is going to be a lot smaller and therefore be able to get more efficient decisions out there.
Thank you, Mr. Conley. Councillor Edgerton.
Thank you, Mr. Brief through to whoever wants to answer it here. We seem to be wanting to put everything into one place where there's water and sewers. And the biggest complaint we're getting next to taxes, or maybe on top of taxes, is the cost of water and sewers. So why don't we get some development out in the open where we can use wells and septic systems, and if they're put in right, they work right, because these municipal things are way too dear to operate for the people to afford them. Thank you.
Mr. Conley.
Through your worship to Councillor Edgerton, the intent of this report and these measures are specifically around the urban serviced areas. So I think if I can make it as crude as possible, the more we have, a larger the denominator, the cheaper it will be. So if you have more people, sorry, the numerator than the denominator. If you have more users, that starts to make the system a little bit more efficient. If you have 2 and 3 units within the serviced areas, you'll have more users and therefore hopefully the cost per unit will go down. You've all preempted my next report, which will talk about the rural area with the idea of increasing densities and certainly more opportunities to that on private services. But I think the province through this and through the next report are trying to make it as even as consistent with respect to urban and rural areas.
Thank you, Mr. Conley. I had 2 questions. The first being probably for you, Mr. Conley, or maybe Rochelle, if she'd like, is with regards to the allusion to these pre-approval or the pre-fees, pre-application, I guess. Is there guidelines or parameters for what those fees are, or is there flexibility within the municipality to based on size or per capita things that where we sort of establish those? I noticed it's in the user fees and charges bylaw that we need to amend. I know there is certain controls over those fees, but I didn't know with this legislation coming from the province if there is flexibility in there or if we're sort of prescriptive as to what those fees are.
Through your worship, I'll answer this. I'm not sure if Rochelle will add to that. What we did was look at what was happening from a process perspective in other jurisdictions, and that's where Big Leary Group has been able to look at that experience. There's nothing prescriptive in the legislative changes through 109 or 23 that say what that rate is. Right now, our pre-consultation is free. It does take a lot of staff time and resources, and what we tried to do with the notion of being measured is not bog down or not lose the goodwill where you have smaller, more straightforward applications, which staff are more than happy to. On the more elaborate ones, it is a lot of staff time. And so the balance there is maintain it free for some of those straightforward applications For other ones, introduce a pre-consultation fee, but that also means that you're going to get the majority of that work that would be there reflected in the pre-consultation in that. And then later on for larger ones, the intention there is that there's a lot of staff work. Pre-consultation will be that much more rigid, but on top of that, it's also something where that fee could be applied to the larger fee. So the intention is introducing a fee where there isn't, again, being careful about when and where we do that. But the other part being that if it goes forward, that application fee can be applied to the other fee that's there.
So if I'm understanding you correctly, there is some flexibility and we'll see what, what other municipalities do or impose in regards to fees. And there will be some considerations for what's being considered depending on those fees. So I'm assuming there will have to be some sort of ratio or some sort of formula that we, for those larger, more complicated applications, that there's a fee associated for those very high complex ones versus ones that are slightly less complex, and then obviously as close to zero for those that are. So we will have a tiered sequence of fees depending on the criteria within the applications. That's what I'm understanding. Okay, very good. The second question I had was with regards to the delegation of site plan control from Ms. Hurley. And this might not be established yet. I know we're sort of early days with some of this legislation and interpreting it. Question being, with that responsibility being delegated, would that mean that obviously council won't have the participation or the controls or the say in the applications or the administration of that? Will those sorts of reports for transparency purposes still be coming to council in the form of reports for information as to this is the site plan control status? I'm just wondering, because we're always asked for the public from site plan control criteria or concerns, and if by delegating it, that's no longer obviously involving council from a decision-making standpoint, that removes that level of discussion and transparency. Is there any thoughts yet as to how we can accommodate still having what has been delegated or what has been moved forward to still meet some criteria for transparency to council and to the public?
Through you, Mr. Chairman, to council and the public, I don't think we've thought about that at this time, but it doesn't mean that it's not an option for consideration. As you know, we do have delegated authority with the director and myself on different other planning matters. So it is something that if we wanted to put it on for information, I don't really see that being an issue at this time off the top of my head, but it's certainly we can, definitely look into for sure.
Very good. Thank you. Any questions, other members of council, before we open it up for the public? Councilor Byrne?
Through the chair, about the presentation, you mentioned there for the parklands, and I don't know if it was a misstep or what, but you were talking about 5% of the value or the area, or is it one or the other or both? How's that work?
Through the chair, it is one or the other. It's not both. So applicants can choose whether they're going to give 5% of the area or they're going to pay cash in lieu of parkland dedication. And then it would be 5% of the value of that property. What I didn't say, because it gets fairly complicated, is there was added to this section of the Planning Act that if you're paying the cash in lieu of parkland dedication, it can't be more than 2% of the value of the project. So then it gets into 5% of the land can't be more than 2% of the value of the development. But that didn't require a change to your official plan.
Who would set that value, or where do we come up with those numbers to say that it is valued at that? Does that get a separate assessment? And then I'm wondering, so that's strictly on the applicants. Council would have no directive at all as to say that we'd appreciate the land rather than the cash?
Through the chair, typically what I have seen happen is that an appraiser's report is completed by a certified appraiser that looks at what the value of the land is based on what your parkland bylaw says. And then it would be appraised and determined that this is what the land is worth. This is what 5% of that cash in lieu is worth. And how it typically happens or as I have seen typically happen is that the determination of whether or not cash in lieu of parkland or raw land is going to be required is done at the time of pre-consultation. So your staff will have a good idea of what parklands are available in the municipality, where the parks are based on what the development is. Are there adequate parks within that neighborhood, or will you require a new one to accommodate the new residents moving to the township?
Councilor Byrne?
Through the chair, on that note, there's that exception that if you had less than 10 units, you didn't need to have that delegation for the site planning. Does that allow a developer that has a plot of land to incrementally do things and just skate below the threshold and kind of get around some of the laws or bylaws or whatever?
Through the chair, that isn't something that I had considered, but it would have to be on a property by property basis. If you're going to be developing a subdivision and each of those units is going to be on their separate lot, that change to the site plan section doesn't impact that. So they would still be going through a plan of subdivision. If you were doing a property that had, phase 1 is 10 townhouse units, and then say phase 2 is another 10 townhouse units, then I'm not sure that section of the act would apply anymore, because you would end up with 20 units on that property. But those first 10 wouldn't be subject to site plan control.
Thank you for that. Other questions, members of council? Councilor Byrne?
Through your chair, on the issue of delegations, I'm reluctant to see council who are elected by the representation of the community giving up any more control than the little bit they have now to see this community move forward and the cost of doing that. So I'm curious of how that works when we relinquish something and lose that control. The chances of getting it back are next to nil, I'm guessing. So I'm worried about the implications of that.
Mr. Conley or Ms. Hurley, would you like to speak to that?
So your worship, to Councillor Byrne, there already are some delegations. We have been doing that. I think one of the things that the CEO, Ms. Hurley, had indicated is we can probably provide a report, sort of an idea of what happens. The notion here in building homes faster and having homes for everyone is that certainly what we've done locally, and I think what the province is trying to do is look at where are the bottlenecks or the areas and where there are pinch points in decision making, what causes delays. That's not to say that there isn't value added by council, but I think in certain situations, some things like removing holding, a good example, Cathcart Crescent. So in preparing that, was a number of those lots were on holding provisions. They were for a number of years. There were studies that had to be satisfied, conditions that were satisfied. Ultimately, they were, but there was a report to council, went back to council. Council did not have an issue with those being approved, subject to that holding. Council would still be in that position of doing that. The removal of the holding would come down to staff or the designate. So in those instances, the delegation is seen for things that are business as usual. On larger things, which are official plan amendments, zoning bylaw amendments, plans of subdivision, significant, larger, major applications, council will still have its responsibilities and its decision-making recommendations. All of those things will still be in place in going forward.
Just a clarification on that, Mr. Conley, and it's alluded to in the next document, which has a lot of overlap with the legislation conversation we're having today. But with the inability for the local municipality and our regulations, whether the bylaws of the official plan, cannot be more restrictive than the PPS or the new PPS document. So isn't that going to be in direct conflict with, with the removal of the holding provisions, all of our regulations that might have local impacts, or that council, as Councilor Byrne mentioned, council can create, more restrictive covenants and things like that, so that they have controls on what the delegated authority can then do and say, the problem being that anything that's more prescriptive than the PPS is no longer allowed. So anything that's more prescriptive in that regard can't exist. So isn't that going to take more of the local autonomy away, or even our ability to create things within that delegated control that have a local flavor? If that's viewed as more in conflict or more constraining than the PPS, isn't that going to then make all of those null and void as well?
Through your worship, what happens there is it really pivots on the definition of what's consistent with and what conflicts with. And quite often they're used interchangeably, but that's not the case. Same with restrictive. So where the PPS is silent, and again, we'll look at and what we have a glimpses of what that will look like. There's a lot of room for interpretation, more narrow than before, absolutely. And there are other policies that really aren't even there, like the natural heritage ones. So when this is all put together, you could have a policy that's gives that local autonomy, which may not necessarily be more restrictive than the PPS. It's a very good point. It's something that, again, we'll have to look at when the dust settles as to what it looks like, and then also bring the official plan. But the PPS does not speak to all matters, and at a local level, it does in some big ways, as you'll hear in the summary of the next report. But notwithstanding that, it isn't to take out all local autonomy, and delegation of authority, again, is still there for council on big decisions. And the idea is that on the smaller ones, which are much more transactional or straightforward, or where council has already made a decision, that's the notion of delegation.
Thank you very much. Other questions before we open it to the public? Council Byrne?
Through you, Chair, just so I'm clear, so we have until sometime in June, early June, so I could have more dialogue with you between now and then, so I better understand all that.
Through your worship to Council Byrne, absolutely. The intention is to bring this forward June 5th, this particular set of OP zoning bylaw and other bylaws, and it will come forward June 5th for final decision at council.
Thank you for that. Good discussion. We'll now look for a motion to open the public, or no, we're in the public meeting already, so we just have to welcome the public. Is that correct? Sorry, clerk. I'm just trying to make more work for you, more votes. Anyways, so same process applies. If anyone would like to come forward and speak, just cite your name and your address in the township, and for the clerk to take the records. And we'll go from there, and the same button sequence applies, so bear with us. Going once, Mr. Steele?
Al Steele, Tapley Quarter Line. I guess my question comes down to a whole one. Actually, it's an observation. As I look here, this is just adding another process at the beginning of the process. So if you double the time and you come in at what you were doing before, you have the time of the process in its whole size. The whole idea behind the two bills that were there is to speed up the process. What it seems like we're looking at is a process that avoids having to do refunds. And is it trying to deal with that side of it? And is it a staffing issue, or is it other processes in it? So when I come back and take a look at the pre-consultation side of things, what moves to that? Does it take things out of the application portion, move it to the front end so that you can spend more time working on it without having any penalty being assessed on the whole side of things? Are we trying to do something out there? And at the end of the day, I guess with this process, is it going to speed up the process? You know, at the end of the day, that's what the whole idea of this process was put in place for. And are we trying to circumvent something and take it into a different realm? For example, who makes the decision when the application goes in? Is that the applicant? In the pre-consultation? Are there a set of guidelines that are there? And at the end of that, then it goes to application. And are the expectations of people set so they know what they're playing prior to going into this whole process? My comments.
Mr. Conley, any comment?
Absolutely. It's through your worship, the council and Mr. Steele and the public. Absolutely. When I look at the spirit of legislation, Bill 109 and 23, the intention was the idea of homes for everyone and also building things faster. When we sat down and worked with Biglieri, it was the idea of looking at what was happening in other jurisdictions and looking at how we could make sure that we're not just, as you're saying, shifting the time it takes now from an application and just front ending it. There is an element of that. However, looking at the experience we've had locally, even on mature applications, the way in which the clock ticks now under the current process, as soon as an application is complete. In other words, we will sit down and have pre-consultation. We'll bring other parties, agencies into that discussion. We'll say you need this, this, and this. So certain studies, so traffic study, environmental impact study, any number of different things that are required depending on the nature of that application. We can get that paperwork in, and what will happen is we'll have a traffic study, but let's say technically it didn't look at certain things. Orca, we work with Orca in a lot of our pre-consultations where they'll sit down and say, well, you need to do a certain study, but the study that comes in doesn't go far enough. We can get a hydro-G study, but does that deal with the geomorphology or all those other things? What happens now is as soon as I have an application with that study in it, it's deemed complete, the clock ticks. What I have then sometimes are studies that are either incomplete or don't go far enough, or there is information that's missing. So what happens is we end up in first, second, third submissions of applications, for example. In some jurisdictions, they'll give you one submission and a resubmission. Anything that's more than that, you have to pay another fee. It also changes the timing on it. I think the points you raise are very good and very important. I think one of the things we'd like to do is be able to look at, with this new process being put in, if council were to approve that, is the idea, what is the timing? Because what we're finding now is, as one of the comment was made earlier, I believe it was Rochelle, the things that take a lot more time are comments from the public, from ministries, from other agencies, where they have a lot of workload, and on top of that, less capacity to be able to provide that information. If we can front end that, well, we have a complete application, it means we have that information there, and therefore the decision points are that much faster rather than the 60, 90, 120, 180 days. So our hope is that when we bring things forward for council, they'll be mature. You would have already had a public meeting. You'll already have pre-consultation. The studies that are being submitted specifically speak to the interests and the concerns raised by the agencies around the table. And then the clock starts ticking on the homework's done. So your point is well taken. I do want to do a pre and post to see whether or not this is achieving what it's supposed to be, with the idea of being able to squeeze the lemon a little bit. The option that I looked at one point was, if we just got rid of the notion of any fees, we get rid of the stress or any of the anxiety around any kind of refund, because it doesn't matter conceivably. It does matter. What we need to do is make sure that applications go forward to a decision, whether that's approval or denial or approval with conditions, as fast as possible. But it also means that the information we get, that we provide, is as robust and complete as we can. But I think, again, once we put the system in place, we'll look at the idea of how quickly it's making those decisions are being made. Probably a breakdown, as perhaps Ms. Furley had talked about, with the idea of anything that's delegated, provide that report card to council. But once those measures are in place, we can tinker with it. I'm not presuming this will be perfect, but I do think it's getting closer to what the intent of the legislation is and what we can manage locally, and being able to do that with the capacity we have. Right now, it's very difficult we're down a planner, have been for about a year now. It's really tough to be able to get the people there and the application, the economy keep going. So we're trying to come up with something that balances that. And if we need to down the road, we would bring forward something to council to tweak that, to make sure that those timelines are reflective of what we expect a reasonable decision.
Another comment, Mr. Steele?
I know it's hard to say, but will the new process work quicker than the old process? And with the commenting authorities, do they have timelines and completion that need to come in play to help you do these type of things?
Through your worship to Mr. Steele, I think the idea is that we're hoping to be able to set what the benchmark is under the new process and work for continuous improvement. With a new process, we will also be working, because everyone is under these new rules in terms of their legislative, they need to be met. So from our standpoint, where we see there are going to be problems over certain agencies, we will be trying to put in very strict timelines of when we turn those over. We do now, but a lot of cases the information will go through second and third and fourth submissions, and that just takes more and more time, and it gets closer to a better product on the fourth submission. But there have been, in some cases, months, if not years, between the first and that one. What we're trying to do is bring that forward. So hopefully better information makes for better and more informed decisions, and then we'll be constantly trying to work towards that improvement.
From a perspective of developers and so on, is there guidelines? Because I've sat through some of the public meetings, and all of a sudden people have decided, well, we need more parkland, or we need something over there, something over there. And as a software developer, working for a software developer who spent a fair amount of time talking to customers about what has to take place when you move a block from here to there. It's not just a matter of a monopoly board moving a hotel from here over to here. There's a significant cost, as I'm sure Wells understands, of doing this. And that's set up right at the beginning so that there is not delays coming back from other people. The question is, are you setting expectations correctly with all the players going into the process? And if that happens at the free side of things, is that going to speed it?
Through your worship to Mr. Steele, the intention is with these new laws, with these new rules and the new guardrails around, the intention is our process will reinforce that. I think unfortunately the province felt it needed to make changes because the timelines that were there in the legislation and the threat of going to the OLT or the LPAT or prior to that, the OMB, were not enough, because then you can wait 2 years to get onto the docket. In some of the sessions through Bill 109 and 23 hosted by other jurisdictions, the words that we got back from the development industry is, we don't care about the refunds, we just want a decision. So that isn't so much of the stick that perhaps the legislators felt it was there. It's important, but at the same time, it isn't the guiding principle for what we do. Like I said, if we had associated no fees with this, then we could more or less say, well, there's no worry, we can just still take our time the way it is. The intention is to build a better mousetrap, and with that, with the agencies, they know what what have been the identifying timelines and guardrails, as I said before, about that, what's there and the expectations. So with that, we're hoping that this process, it will front end a lot of that work, and it really does sort of pain me to say, okay, are we doing that? But I want to be able to empirically be able to come back and say decisions are coming forward, and they're coming forward in a faster way. And if the information is there more complete, which is a big part of what we do, that back and forth and refinements, if that can be narrowed down and front-ended, my hope is that definitely decisions will be there. Overall, we have to look at the process from beginning to end. Again, right now we have mandatory pre-consultation. It has been free. And with that, we've always been open to being able to sit down and talk as staff, and we don't want to lose that part with anyone who's coming forward, just simply for clarification. But on the things that are much more significant and will go forward, this is the process we're hoping to put in place. And like I said, if it's not perfect, we'll make revisions and bring stuff back to council. I know council will be very mindful of how much time and the resources associated with that.
Thank you, John. Other member of the public be wishing to speak? Going once. Yeah, Marnie, welcome back. Just your name and address, but we have that I think already, but just for formality, if you could.
Again, Marnie Saunders with DM Wells. Without having to echo the comments that have already been made, I do appreciate that timelines in the Planning Act don't necessarily allot staff the time that's necessary to complete those reviews, especially when there's more than one that come in. My main concern about the pre-application process, which, like it's been said, a number of other municipalities are following similar suit or have introduced similar processes, which in my experience so far, and I guess, again, these are very fresh processes and new, they do just extend those timelines or circumvent those timelines. So where you could go through 3 or 4 submissions when you get to the actual planning process, they're still saying, like the city of Peterborough is saying, you could still go through 3 or 4 technical adequacy reviews before we would accept. So for instance, I've waited 90 days so far and they still won't let me submit a planning application because I'm still circling through the technical adequacy review, which the first review is clerical issues on the cover letter. So where's the technical adequacy in that? So that's my concern. I think the bigger problem is, or maybe another solution could be a more substantial pre-consultation meeting where I think the minor and major is really important, but also providing the level of details and in terms of references for the studies and submission materials that are necessary. So you're not getting inadequate submission material when it comes time to look at that within that 30-day time period. And I do appreciate the level of demand on the services for planners across all municipalities and the understaffing issues that are happening not only on the municipal side, but the private side as well. We're all feeling it. So I don't think that the refund was necessarily a very good solution to the problem. Previously, the only alternative to, or the only exception of getting a decision outside of staff beyond those timelines is going to the tribunal, which is extremely costly. So unless you're a developer with deep pockets, you're not willing to go to the tribunal. You're willing to wait the time out that it takes for staff to make a decision, because ultimately it might take a bit longer. You might be 2 or 3 years of board after that, and hundreds of thousands of dollars more in debt versus forcing a municipality to give you a refund on those fees, which isn't fair either when they've already done the work and it might have taken a bit longer, or they needed a bit more time to do it. So I don't know. I do see that the pre-application process as circumventing those timelines in some sense, where if we could come up with a better, more in-depth pre-consultation process, so knowing when you do receive that information, it doesn't necessarily need that level of review or resubmissions before we can actually submit a formal planning application. But that's one of my major concerns with the whole pre-application or technical adequacy review, is it can extend those timelines indefinitely until staff's satisfied that the material that they're getting is acceptable. That's my kind of comment.
Is it appropriate to make a comment or ask a question? Because we've already had our kick at the can, so I just want to be respectful of process. Ms. Hurley or Ms. Page?
Through you, Mr. Chairman, if I may, I would suggest you continue with the public first and then make council's comments after.
We will do as instructed. Any other members of the public wishing to speak? Well, you can try. All you can do is try. Yeah, trying's free. Just head up there, sir. Just your name and address. So hit that. I'll hit my red button off. You'll hit yours.
Yeah, I'm Nick Rikers, Morton Line, Cavan. I've been there for 37 years now. Say that again. I just said that. Oh, Nicholas Rikers. And NICOLAAS. Address is 1308 Morton Line. Okay, I've been there for 37 years now, and I've been passing this idea around with my wife about hopefully be able to sever 1 or 2 lots off the back of the property. I've got a 100-acre farm, 101.8, I think it is total, between Morton Line and I think it's Stewart Line. Is that right? Jerry knows. Anyways, I wasn't here, but I did talk to the township about 3 years ago and asked about this severance to build a new home. They told me no, unless you sign a piece of paper that when the new home is completed, you'll tear the old one down. Right now, it's an old farmhouse. It's all renovated. It's a beautiful home and everything else. We don't want to tear it down. But what I was hoping to be able to do is sever 1 or 2 lots off the back. Would be Stewart Line, I guess. And I would need the money, obviously, to build. So all I need really is yes or no, or possibly a maybe. Is it worth a while for me to apply?
So that pertains to the next report, but there isn't an opportunity to speak, so I'm glad you got your chance to, but I encourage you to listen to the next report because that is the piece of legislation that's just changed a lot of the provincial standpoint on how municipalities have controls over where development can be allocated. So that subject matter is not within these two reports for 23 and 97, I believe, sorry. And then, so 109 and 23, and then 97 is the next one that is the new legislation pertaining to more rural development. So stick around for that, but the question's heard, and I think you'll probably find your answer from some of the presentation about that document.
I thought I got that right, okay, but that's why I put the question forward. So thank you. Thank you.
Mr. Conley might want to fill in some of the gaps that I left behind.
Through your worship, it is the subject of next report, but in that, under the changes with the province, so much like the changes we had here with the idea allowing for accessory apartments or additional residential units within serviced urban areas, Bill 97, if passed, which is all strong likelihood it will, is the indication that you allow for more intensification, like second and third dwellings in the rural area, in farm, typically around a farm, but on top of that, severances on top of that. So going a little bit further to be suitable for the more rural environment, but that's what Bill 97 is doing, and that's right now making its way through provincial legislation, through council, through committees, and then back to the legislation. But where it would have been a no before, because the PPS, provincial policy statement, and our official plans didn't allow that, looks like the legislation and the provincial policy statement will be changed to be able to allow that kind of scenario you're talking about.
Thank you, Mr. Connolly. Anyone else in the members of the public? Going once, going twice, seeing none. Very much. We are just consideration of the report before us, that we consider all verbal and written comments received at the public meeting, and that the draft plan, official plan amendment, the zoning bylaw, and other bylaw amendments be presented to council at a future date. Moved by Councillor Byrne, Councillor Natchoff, all in favor? That is carried. Now we need a resolution to close the public meeting. Councillor Byrne, Councillor Edgerton, all in favor? That is also carried. Thanks, everyone. Do we need a short break, or are we good to keep going? Members of council, good? Well, most of the public meeting is done now, so I think we'll just continue to proceed if everyone's okay. All right, next before us, we have a number of sets of minutes, 9.1 and 9.2, minutes of the regular and minutes of the special meeting. The regular meeting held May 1st, the special meeting held May 4th, 2023. We can do one motion for those two sets of minutes, that the minutes be approved as presented. Councillor Natchoff, Councillor Byrne, all in favor? That is approved. The next, we have 10.1 minutes from the Millbrook Valley Trails Advisory Committee meeting on February 27th and March 27th, be approved as presented. Councillor Natchoff, Councillor Byrne, all in favor? That is approved. The next is the minutes from the Downtown BIA Board of Managers from their April 6th meeting, be received for information. Moved by Councillor Edgerton and Councillor Natchoff, all in favor? That is approved. Very good. We move to the reports section of our agenda today. Reports is Bill 97, Helping Homebuyers Protecting Tenants Act 2023. Mr. Conley. I didn't want to, we lost our audience for your report, John. I'm sorry. He'll check it on the online after, no doubt.
This happens at home too, anytime I go to speak. Through your worship to council, you have before you Planning Report 2023-24, Bill 97, which is Helping Homebuyers Protecting Tenants Act 2023, Environmental ERO, Environmental Registry of Ontario posting comments. Recommendations, there are three of them. The council will receive report planning 2023-24, Bill 97, Helping Homebuyers Protecting Tenants Act 2023 for information. Secondly, that council directs staff to provide correspondence, that being a letter to the ERO outlining council's concerns with respect to Bill 97. And lastly, that a letter outlining council's comments be submitted to the ERO as the township's formal written submissions regarding Bill 97 prior to the comment day deadline of June 5th, 1923. There's a lot of material here, sort of planning day in the township today. With this though, this is on top of all the other changes that were through Bill 109 and 23 that we just talked about, is the province going further to implement more changes, sort of wide sweeping and broad changes to the land use planning process and decision making. With this, Bill 97 contains a lot of things, but specifically the report here focuses on the provincial policy statement. Provincial policy statement's been around since 1996. Prior to that, in Ontario, each ministry used to have a planning statement. In a lot of cases, that was, some of those were complementary. In other cases, they were sort of at each other. So the province in the 90s, through the provincial policy statement, developed their set of provincial interests. In this most recent, and what was under Bill 23, they've taken the growth plan for the Greater Golden Horseshoe, and they're going to implement that as part of the provincial policy statement. What that will mean is the current PPS will be basically changed, will be canceled, so to speak, and the growth plan for the Greater Golden Horseshoe will be rolled into the provincial policy statement. There are a lot of changes that are here, significant document. It's in the attachments that have been provided to council. What I've tried to do on page 101 of the report in your agenda is identify a number of the areas, and in that some highlights. So in the housing section, one of the things that is going to be a significant change is the removal and intensification density targets as a mandatory requirement for municipalities. That was something that this and previous council was intimately involved in as part of the Peterborough County Municipal Comprehensive Review as to how we could work with the growth that has been forecast in this township to the year 2051 and how that will work with the other 7 municipalities as well as the county's official plan. The targets to 2051 are still being maintained, but the idea that they can have higher targets achieved at a local level. Planning is still for a 25-year growth horizon, and then there's been expansion of the housing options. One thing of note, though, is the removal of the definition of affordable housing from the provincial policy statement. That was the test of 30% income rent to own criteria. That's been replaced with the notion that under the inclusionary zoning, which is under the Planning Act, that's how affordable housing will be achieved. The other part is the increasing of additional housing options for rural housing. And that in this case is the permitting up to 3 new residences on existing properties. This is to recognize multi-generational farming families, but also enhance lot creation. The idea that you can have for those second and third dwellings, some of them could be accessory, but other of them could be dwellings, a separate apartment that are separate building, is that you can have 2 more severances on top of the existing one in order to create those severances and those dwellings. Another area is settlement area expansion. When before under the growth plan, you could only remove, you could only use the municipal comprehensive review to expand the boundary of a settlement area. They can now be applied, they're application driven, and the tests that were there no longer have, that were there for the growth plan, no longer need to be satisfied. Employment protection and conversion, with respect to that, it's the idea of allowing protecting employment areas and from permitting more commercial uses not associated with the primary uses and institutional uses. But on top of that, removing what was at one point called provincially significant employment zones. The intention there is that through the PPS is to recognize employment and those corridors as being important, regardless, they do not have to be designated as such. With respect to working with the schools, is directing greater collaboration between planning authorities and school boards. We do have a working relationship with the school boards, but on top of that, this is sort of directing that with the idea being more collaborative and also providing some more innovative approaches to designing schools and the facilities and the other things associated with that. Land use compatibility is the key protection of existing or planned industry, industrial and manufacturing. But what was a concern before was sometimes you'd have sensitive uses. This is sort of changing the test to say that where there was a requirement for the proponent of sensitive land uses to demonstrate a need or evaluate alternative locations, now it's the idea of just avoiding or looking at adverse effects is the idea of being able to have tests that allow that to exist without having to move. Again, encouraging industrial manufacturing, small scale manufacturing in the strategic growth areas and other mixed use areas. Natural heritage, this is a big hole in the provincial policy statement and the growth plan. Significant wording now in the existing growth plan and the PPS talk about natural heritage features and functions. As of now, Bill 97 and the new PPS has not changed it. It's silent on what changes, if any, are coming. And even as of today, there's nothing been changed on the Environmental Bill of Rights with respect to providing greater detail. That makes it difficult for us as staff and certainly as an organization to say whether we're pro or against some of these policy changes because it's lacking that sort of third leg of the stool, so to speak, with respect to how this is balancing housing needs, social and economic needs as well. On the agricultural side, it eliminates alternative evaluations for settlement area expansions. It allows or promotes the idea that where there were difficult tests, where expansion areas for settlement areas were being agricultural areas, the tests are lower in that respect. Eliminates the requirement to use provincially mapped agricultural system. It was something that was a requirement before. You could have a local alternative of being able to identify those agricultural lands. The other thing here is permitting additional dwelling units on farm operations, as I'd indicated before, as well as permitting land extensive energy facilities like solar farms or battery storage, things of that nature. Lastly, one of the more significant things is the minister's powers that will be changed under the new PPS. This will give the authority to make regulations and orders related to planning functions that used to only be for local municipalities. In that case, the municipalities cannot enact policies that are more restrictive than the PPS, as you had indicated before, Your Worship. But in this case, it also increases authority in the role for minister zoning orders. What that means is that it can require all municipal decisions, including zoning bylaws and permitting process, must be consistent with the PPS, even before a municipality's official plan has been updated. So before, when the PPS or changes to the PPS or the growth plan were put in place, there would be a transition time. The way in which this reads right now is once the PPS is approved by the provincial government, those policies will be in place right then and there, and any decisions on a go forward basis, even before we've updated the OP, even before we've updated the zoning bylaws to reflect the new PPS, those will, we don't have to wait for those will be updated at some point, but all decisions have to be consistent with this new PPS. What that's done is create a bit of a list from staff's perspective, and we're putting this forward as attachment to the report, where in essence, we have provided 9 areas where we support the new PPS, 6 areas where we do not support, and there are 4 areas where we have identified that we have concerns. That report or that letter is attachment number 4 to the report itself. And with that, if you have any questions or anything in more details, happy to answer those.
Thank you, Mr. Conley. It's an extensive report, and yeah, there's definitely lots in here that really changing the horizon and landscape of how we do things. Questions, members of council? Councilor Byrne.
Through the chair, I was informed a while back, years ago, for the settlement expansions and designations of where limits are. And I don't know if that just required the hamlets or settlements or all the other terms, but it was a designation that you couldn't cross a roadway, a railway, or a waterway. Does that change anything? Am I even clear on that understanding? And how's that affect moving forward?
Through your worship to Councillor Byrne, it used to be before that from planning standpoint, we would look for things that were natural separators of residential uses and the rural area or agricultural uses. So you would use railway lines, roads, things like that, hedgerows as logical separators between how a hamlet would grow and it wouldn't. Under the growth plan as it exists now, there were no creations of new settlement areas. And so under that, we couldn't do, as we had sort of indicated in the last official plan, was create any settlement areas. Like Crestwood was one of those areas that was to be identified. Notwithstanding our efforts, the growth plan did not permit that. The county did not approve it. It did not go forward. What's happened now, and what will happen now if the PPS is approved in its current form, is that the logic will still be protecting certain things like prime agricultural lands, but there's more flexibility to expand. The growth plan would say that you had to have a municipal comprehensive review to provide the justification and need. So you needed to know the population growth was there and the number of units were there. That would give you the idea of the land that was required. If it couldn't be accommodated within the settlement area, then you could expand it as justification. That is more or less thrown out the window through this. So you had density targets and intensification targets. Those don't apply. So what was more like a land economics basis for how planning act decisions were made, that is more or less being turned on its head. I don't believe it allow for settlement area expansion willy-nilly, but what it will do, it's not a technical term, but what it will do is allow for the creation of new settlement areas which weren't permitted before. And for those that are there, they can be driven by an application. And the test that was there, which were the official plan policies that didn't allow it, or the PPS or reference to the growth plan, those are no longer backstops to prevent that type of thing. Again, the hope is that any expansion is justified, that the right reports and justification is there from a science evidence-based perspective, but the policy backstop, which didn't allow it, that has more or less been weakened or in some cases eliminated.
Other questions, members of council? I had a couple. One, I'll do one and then we'll see if anyone else has a question. With regards to the coordination with, I'm sorry, I was just not seeing it there, but I have it highlighted here. So let me go back to here. The greater collaboration with school boards. This has been a bone of contention for a number of years with this municipality. Is there any more details that we have at this point as to what that actually means versus just an insinuation that it should happen?
Through your worship to you and to the rest of the council, there isn't any detail as to how that should happen. I think if I were to lean on my experience in working in other jurisdictions, maybe faster growing ones, the intention is that school boards have a particular way, a particular path as to how they plan. If you're looking for a high school or an elementary school, there are certain templates that they use. I know in some areas where there's been the idea of looking at the common field space, so where you'd have a playground or other facilities, other recreational things associated with schools. I know in some jurisdictions that I worked in, the idea was that how could that serve a community need? There's been resistance to that. I think the intention here from what I read and certainly from the briefing material that was attached to the legislation and what the changes are, is that certainly municipalities could work closer with the school boards. And even though we do work with them, I guess the idea is where can we identify under this new policy regime, where there are places where we can serve multiple purposes when development comes forward.
Sure, but and I guess to follow up on that, I mean, provincial planning legislation doesn't have any jurisdiction over school boards, so it could only suggest municipalities do more in the way of coordination versus what the school board is regulated under. So I guess that's the extent of it, if I'm not mistaken. Ms. Hurley?
Through you, Mr. Chairman, to council, I think there's a bit of an overlap on the timing, you know, so we as planners can plan the process about where development takes place. The school board, I believe, plans after the fact. So there's always an area where we need to continue to negotiate and to have discussions, but the fact of the matter is the planning timelines don't always line up. So that's our past discussions with the school board, and it's about when growth is coming in our horizon, we've identified growth. However, the school boards don't recognize that growth till a certain time.
Thank you, Ms. Hurley. Mr. Conlon?
If I may, your worship, to you, to council, I think some of the other things that the province is doing with respect to other legislative changes is being able to take more control with respect to school boards. One of the initiatives is to have power to be able to look at the lands that school boards hold and identify those as surplus and be used for other needs. And typically those other needs are going to be for housing. So I think the province in other areas, other legislative parts of its agenda and mandates are looking to see how it can exert or start to impose a better working relationship or an idea of what they consider collaboration. And I think from an affordable housing standpoint, certainly in other jurisdictions, we saw things like school sites or something that would be a surplus school site would be ideal for either housing, affordable housing, things like that. I think the province is starting to take a little bit of a stronger hand, or has made it clear that they'd like to take a stronger hand in being able to put those decisions further and foremost with respect to housing.
My next question is, anyone else want to jump in with a question? No? Okay, I'll keep going. My next question is for a bit of clarity with regards to the agricultural protections. There's some soft language, I would say, from my perspective. Granted, I've only been doing this for a few years now. There's fairly soft, flowery language about the insinuation that there's going to be a maintenance of agricultural land protections. But then when you go through the actual adjustments to the legislation, all it's talking about is the cannibalization of agricultural lands. There's nothing really that it speaks to me other than for certain requirements for specialty crops such as grapes, which is not like it's a prevalent thing sustaining the entire food cycle with grapes in our province. Is there, I guess I'm just trying to read through the tea leaves here and just sort of see what you're really putting, in my opinion, the smaller farm operations in a real sort of Sophie's choice circumstance where, say I'm going corn on roughly 160 bushels an acre. my net revenue from 160 bushels an acre, which is an average year, depending on the price of corn, which is now about 635, I think, so it's statistically high, you're looking at $1,000 net before your cost of fuel, before your cost of labor, before any machinery updates and things like that. And versus the value of the land that we just talked about, a smaller parcel being, $200,000 to $300,000. So we either got to farm it for 200 years, or I can sever and create a lot. And my issue is that we have hundreds of agricultural properties in the township. And this can theoretically jeopardize, conservatively 2.5 to 3 acres of each of those farms. And fiscally, you're putting them in a real hard circumstance to even consider sustaining the farm as it exists versus severing these lots. And I think once you begin the severance process, I think there's some entitlements that are very deserving of the severance, but to go to 3 and then have the existing auxiliary buildings that are by right of to each of those properties. So you sever these acres, then there can be up to 3 dwellings on those acres. Like, this is a real huge implication with how land use development is going to occur, and can create a myriad of issues, whether it's fire suppression and fire treatment for these auxiliary properties that might be hidden, they're not accessible to the road. I guess to come back to my main question, what is actually in this that's actually going to protect agricultural land?
Through your worship, to the rest of council, and specifically what you're raising, the idea is that there still is the idea of protecting agricultural land, but it's also the balancing act of how do you create more opportunities in the rural landscape to allow for housing. From our standpoint, in the absence of the detail, which there isn't, the provincial policy statement is an umbrella. Large policies, the actual enacting part of that would be our official plan, and then down to the zoning is how do we create that balance to make sure that it isn't, as you said, Sophie's choice. So the concern would be with the number of farms we have is how would we minimize the footprint where you take a farm, like a dwelling, you take the accessory buildings to it, then you add the accessory apartments to it, and the notion that right now, I think people picture, I've got one farm, I can add a second and a third, and I can sever those. Couple that with the idea that you can have a farm help house or an accessory apartment, you're talking 3, 6, 9 opportunities with respect to housing. That has a draw on waste management, on waste collection, on a number of the municipal services. So in the absence of that detail, I think your point's well taken, that we try to minimize the footprint of what's going to happen. So the idea that you can have those severances, but the idea is that you minimize how much of the farm, the operation of the farm. There was a time from a policy perspective that you would have a number of severances in the rural area. We have over time through the official plan, through the provincial policy statement, and even in the growth plan, narrowed that down to, in some cases, you can either have one or none if you've already had that severance. This opens it up. I think from our standpoint, what we recognize is that anything that goes forward has to have the lesson of being made sure that it's measured as to what we can do and what it will do from an implementation standpoint. The PPS doesn't provide that detail, but I think if it's a concern, it's something we as you as council and we as staff should identify as something that needs to be considered, because I can understand and appreciate where this is trying to even out the creation of housing opportunities from the urban area through Bill 23 and now in the rural landscape. But that has to make sure that it doesn't so at the price of loss of prime agriculture.
Just to expand on that though, Mr. Conley, wasn't one of the controls that we traditionally had that is no longer coming forward was the number of the growth allocation. Like, we used to have a number to pursue, and that once if it was fulfilled or pursued, then that would dictate the number of rural severances that were available in a given time period. But now those numbers are no longer existing. So, there's no really calibration of the growth whatsoever. So there isn't any, I don't see any municipal controls that might be able to mitigate this amount of severance and this amount of development in rural areas by right. So if there are, I'd love to hear it. But to me, that like I said, there are some instances where I think it's been a shame that some, from a retirement severance lot, things like that, like I fully support those sorts of things. But this is talking about really fundamental foundational changes to the rural landscape. And it creates a myriad of issues, and it's also doing so at a time where development charge revenues to offset these implications, which are in some cases greater cost services the more remote they get. It's never been less affordable for municipalities to try to pursue this sort of thing. So I guess my concern is I just haven't been able to find in the T, and I know that there's more coming and more refinement coming, but to me, this is going to result in, just from a fiduciary standpoint, there's no incentive to continue not to pursue
this amount of severance work. And my understanding, there's no quantification or limitation that municipalities could impose on the number or types of this amount of growth. And there's obviously going to create its own pressure for all of the timelines that we just discussed in the other areas that are going to still pertain to rural growth as well. So, I mean, talk about a rock and a hard place, but it, you know, there's a lot of nice language about sustaining agricultural and balancing, but there's no actual sticks when it comes to balancing or fading off these sorts of development. And unfortunately, you know, there's no fiduciary reason to do it either. So I just don't see where that flowery language is reinforced with any sort of policy. So if there is certain things, or do you think there's a criteria by which we might be able to limit all of the farm properties and being entitled to this sort of severance activity all at once, I am all ears.
Through your worship, those are all very good points, and I can't refute those. I think what the provincial policy statement does, it would allow up to these number of severances. A lot of that's dependent on the situation. So you need to have it on private services. So you need to be able to satisfy whether or not you can put a bed in, you can have the reserve space. Is there water there? Are you able to do that? There will be some physical limitations from the places across the township, which will not allow for that second and third severance. The language that's there doesn't provide the detail, but the PPS shouldn't be so prescriptive that it reduces the ability for the local municipality to have that autonomy to put those guardrails in. Our official plan and zoning bylaw, if this is passed, are the things where we would put those safeguards. The points are all well taken. I think, again, the intention here was to even things out, allow for that growth. But the downside is, much like before when farm retirement lots were permitted, we found that a study from the province was that the tenure for that was around 3 or 4 years, and then it would go to elsewhere. So it wasn't the intention if someone works the land for their life or multi-generational, they're able to stay on the land. The facts actually bore out that they weren't able to stay on the land. So it's a balancing act, and in the absence of that detail, we would look to the official plan or zoning bylaws to try and bootstrap the idea that we are still trying to protect the environment and agriculture specifically around that, at the same time allowing some degree of opening up the gates in terms of development. But there are a lot of things attached to that and concerns.
Other questions, members of council? I only had one other point, Mr. Conley, and if you behoove me, I don't know if it's a reconsideration or adjustment, but in the last bullet point, I just thought that some of the language, I know in being somewhat tenured now in the advocating to the province that, you know, and maybe it's more formal in notices of motions and things of that nature, but the language in the last bullet point, I mean, to me, and I'm just speaking from my own perspective, but, you know, from what I understand from our municipality and the things that we are trying to do, I mean, we support the province in pursuing more housing. We understand the need, and I think our municipality is pulling our lion's share of the weight when it comes to trying to create as diverse an amount of housing as possible. That being said, I think my issue is that, you know, all of these alterations are done in the pursuit of efficiency. However, they're not respecting the fact that all of the efforts and trying to correspond with a lot of legislation, be it at the county OP and things like that, that staff have invested hundreds and hundreds of hours in over the last few years are now redundant. And they're redundant almost immediately or within a 6 month horizon. Like, to me, what I would like that last paragraph to allude to is that if you're going to propose foundational changes in planning legislation like this, you need to do so that with giving municipalities more of a head start on not doing and investing in hundreds of thousands of dollars of a lot of arduous work that is going to be redundant at the flip of a switch, because there are certain policies and procedures and things like the growth allocation that we wouldn't have had to go through and spend, you know, hours contemplating and trying to strategically organize that are now worthless. And without giving municipalities enough notice or enough lead time to even submit, I would say, you know, wholesome comment as to our concerns and consideration. That's, to me, what we really mean and what we're really trying to say, or what we should try to capture. Is that we fully support the intent, but the way that we're going about it with these foundational changes, it creates so much inefficiency. I don't know if we'll ever catch up to saying that the changes were efficient. And, you know, I know from my experience with developers of all shapes and sizes, whether it's one house or, you know, 400 to 700 houses in our community, you know, we get a lot of compliments from a planning processing standpoint. We are not a municipality that's delaying, but we are at the mercy of all of these commenting agencies and all of these different contributors, and even the developing community, because I've seen the documents that we provide in pre-con. We tell you everything you need to do.
And then, you know, it could be a year later and we're still not receiving any of the comments or any other corresponding information from the developer. And we would have been transparent, but there's just a feeling that was not necessary. And now the other concern is that by the flip of or the stroke of a ministerial pen, they don't need to do it either. So I guess that's one of the things that I just didn't feel was really captured in that last comment, that I'm not sure if that was enough of the direction, and I'm not trying to speak on all of council, but I think it's important that we mention as a municipality that we are supportive of what their intention is. We do have concerns about the way that's going about being rammed through without the opportunity to provide local comment. We're being treated like all municipalities are the same. And, you know, with some of the things from the contribution that our agricultural residents make to the food system and the province as a whole, that's not being respected by just ramming through these foundational changes in legislation without the foresight as well. So if council is amenable and not okay with that vein of commentary, I'd ask that John consider that and making certain adjustments into that last paragraph, just so we capture that, because I think it's important to tell the province that we do support the intention, but we're concerned about the implications and the inefficiencies of how it's being done. So, Councillor Byrne.
Through the chair, on that note, at the very preamble of this whole discussion, the province announces in it that they've done all this consultation, and I've yet to find anybody at any of the conventions or any of the discussions I've had that can say that they were consulted. So I don't know if it's worth I'd say something, but it's not.
Mr. Conley.
Through your worship, the council, I'll definitely make those changes. And when I looked at the report later on, I realized that was a little bit more whingy than I wanted it to be. Not sure, again, that's a technical term. Exactly. But definitely we can certainly reinforce that and make sure the wording reflects that. With respect to Councillor Burning, your comment about these proposals that go forward, one of the last times I brought a report with comment and input from council. By the time council had looked at it and it was ahead of the deadline for the environmental posting, legislation had already been passed. I checked with this legislation, hasn't been passed yet, but it had a day and a half of hearings last week, the 10th and 11th at committee level, which means it's gone through second reading. It'll go back to the House for third reading. So I will get this out, change the wording accordingly if that's what council wishes, as soon as possible, with the hope that the legislation hasn't changed by that time prior to June 5th. But your points are all well taken, and I do appreciate that.
Thank you, Mr. Conley. I just wanted to confirm everyone's okay with that sort of tonality and changing in that last line. Okay, that seems good. Thank you. You don't need a specific direction for that. That's captured. Very good. So that being said, if there's no other questions at this time, there's three recommendations in the report. First, that council receive the report with regards to the Helping Home Buyers Protection Tenants Act for 2023 for information. That council directs staff to provide correspondence to a letter to the ERO outlining council's concerns with respect to Bill 97, and that the letter outlining council's comments be submitted to the Environmental Registry of Ontario as the township's formal written submission regarding Bill 97 prior to the commenting deadline of June 5th. Looking for a mover and a seconder. Councillor Byrne, Councillor Natchoff, all in favor. That is carried. Thanks, everyone. Really good comments, good discussion, and thank you, Mr. Conley, for all of that background work. We move on to the next item on the agenda, which I believe is the CAO's report. Ms. Hurley, anything to speak to?
Through you, Mr. Chairman, just one item. It's with regards to the noise bylaw review. We did carry out that review, and I wanted to let council and the public know that we did have our meeting with the Peterborough Police, and the police have everything they need to enforce that bylaw. So therefore, from our discussions with us, they will be going forward with enforcement. And if you remember, that came out of some of the noise issues that we had with regards to the Millbrook Cathedral.
Thank you, Ms. Hurley. Any questions? Other than that, we're just receiving the CAO report and capital status for information. Councillor Byrne, Councillor Natchoff, all in favor? That is approved. General business, there is no general business on the agenda. Correspondence for information, there's a letter from Honorable Braden Smith. Oops. Very good, thank you, clerk. Verbal updates from committees, members of council. Councillor Edgerton, I believe, has one.
There we go. We had our meeting on May the 12th of the municipal revaluation, and on the committee, and we went through the Parks and Recreation Master Plan for 2035. Yeah.
Thank you for that. Yep, you got it. Any other updates? Seeing none, the next library board meeting is actually tonight, so I'll have one for the next council meeting with regards to that. So excellent. I need a mover and a seconder for those for Mr. Edgerton's comments. Councillor Byrne and Councillor Natchoff, all in favor? That is approved. There is no general business now. We do have the corresponding letter from Honorable Graydon Smith, Minister of Natural Resources, regarding spongy moth outbreak. This is the new terminology for what was previously known as the gypsy moth. So that letter is for information. I'm just looking for a mover and seconder to receive. And as the council is directed, this will be posted on the township website. Councillor Edgerton, Councillor Natchoff, all in favor? That is approved. There is no correspondence for action. We now have our bylaws, 15.1, bylaw number 2023-32, being a bylaw to execute an agreement with the Behan Main Street reconstruction. Moved by Councillor Natchoff, seconded by Councillor Byrne. All in favor? That is approved. I think I forgot to read the first, second, and third time, but I will do that now. Being a bylaw to execute an agreement with Meehan Maker be read a first, second, and third time, passed this 15th day of May, signed by the mayor and the clerk, and the corporate seal attached there too. And you have your secretaries. That vote was approved. Very good. There is no unfinished business. Any notices of motion? Seeing none, we now have our confirming bylaw. That bylaw number 2023-33 being a bylaw to confirm the proceedings of the meeting held May 15th, 2023, be read a first, second, and third time, and passed this 15th day of May, signed by the mayor and the clerk, and the corporate seal attached there too. Moved by Councillor Byrne, Councillor Natchoff, all in favor? That is approved. Now look for a motion to adjourn the meeting. Councillor Natchoff and Councillor Byrne, all in favor? That is approved. We have a number of upcoming meetings. I believe it is, what time is it now? Just after 15, so 3:15. We got that for adjournment. Upcoming meetings, Millwood Valley Trails Advisory Committee meeting, Monday, May 15th at 4 p.m. in the council chambers. Cabin Monaghan Public Library Board meeting, as I mentioned, is tomorrow night rather, at May 16th at 7 p.m. at the Millbrook branch. And the Millbrook Downtown BIA Board of Management meeting is Thursday, June 1st at 8 a.m. in the council chambers. Our next regular council meeting is Monday, June 5th at 1 p.m. in the council chambers. The Municipal Revitalization and Heritage Advisory Committee meeting is Thursday, June 15th at 9 a.m. in the council chambers. Our subsequent regular council meeting is Monday, June 26th before the summer break on 1 p.m. in the council chambers. We also want to make note of the Canada Day celebrations are being held at the Cabin Monaghan Community Center Saturday, July 1st from 11 till 2 p.m. And then we do not meet again as a council after in July. And so the next regular council meeting after that is Monday, August 14th at 1 p.m. in the council chambers. Thanks everyone for attending today.